Hi everyone, we are Group 1. Today we're going to be talking about Chapter 6, School Personnel and School District Liability. I'm Caitlin.
I'm Laura.
And I'm Drew.
So, the school is a safe place. It should be noted that teachers and administrators are held to a higher standard of care than the ordinary man on the street. The teacher administrator is under the duty um, to possesses more than the ordinary amount of intelligence to in relation to the students and their care. So our expectations are more than just some random person who would see a kid. Schools are presumed to be a safe place where teachers teach and students learn. Obviously, parents and guardians aren't going to send their 5-year-old to a place that they don't think that they're going to be safe. The prevailing view held by the courts is that prudent professional educators acting in place of parents are supervising students under their care and ensuring to the greatest extent possible that they are safe. So, liability of school personnel. School personnel are responsible for their own um, tortious acts in the school environment. Liabilities involving school personnel normally falls into two categories: intentional torts and unintentional torts. So kind of like if an accident were to happen, that would kind of be what a tort would be. So whether it was intentional or unintentional. Intentional torts such as assault, battery, liberal slander, defamation, false arrest, malice prosecution, and invasion of privacy require proof of intent or willingfulness, whereas simple negligence as an unintentional tort does not require such proof of intent or willfulness.
Vicarious liability. Since school districts are deemed employees of teachers, they also may be held vicariously liable for the negligent, I can't even say it, behavior of their employees. Under the old theory of respondent superior, the master is only responsible for authorized acts of its servants or agents. So foreseeability is a crucial element in liability cases, especially if cases involved negligence. So foreseeability is defined as the teacher's or administrator's ability to predict or anticipate that a certain activity or situation may prove harmful to students. Well, so once this determination is made, there is an expectation that prudent steps be taken to prevent harm to students. Failure to act in this manner may result in liability claims. So, an assault is an offer to use force in a hostile manner, which causes apprehension. The person being assaulted normally must feel a degree in the sense that one is committing the assault, would execute it promptly, and has the apparent capacity to do so.
Continuing that, we have the aspect of battery. Battery has occurred when a physical contact actually takes place. In practice, a battery is a successful assault. So say that a student punches another student and causes harm, leaves a bruise, draws blood, perhaps that's assault. Battery involves unwelcome and unprivileged body contact involving another person that's hostile and unlawful, hence drawing blood, leaving bruises, leaving marks, so on and so forth. Assaults and battery affect teachers, administrators, and students in the school environment. So anybody that is within the school building is going to be impacted by any sort of battery. Every person is responsible for his or her actions in cases involving assault and battery. So, say a teacher sees an incident happen, they're also responsible for his or her actions, along with any admin, any staff that might see it or may have heard about it. They got to be able to um, deal with his or her actions. Now we have defamation. Defamation occurs when false statements are made about another person, essentially lying. These statements generally are ones that tend to harm a person's good name, reputation, or subject the person to hatred, contempt, or ridicule. Certain statements are privileged if made in good faith and within the scope of educators' duty. Therefore, school personnel who expect to be protected by qualified privilege must not make false statements regarding students or colleagues with malice or intent to harm. So, in the world that we live in, people are going to change and edit some words or how things went with a certain situation, and they might put those words into a hatred way or make things worse than it possible or worse than it was, so on and so forth. Libel and slander. So libel is written defamation, whereas slander is considered oral defamation. Both include statements or communication that results in injury to a person's reputation, good name, or standing in the school or community. A third party must be privileged to this communication with established defamation. The burden of proof rests with the person who claims injury based on defamatory statements.
So kind of taking a bit of a more serious turn, we have false imprisonment. False imprisonment occurs when a student is detained illegally by the teacher or the principal. False imprisonment false imprisonment is considered to be an intentional tort. So if you don't have any proof or grounds to be restricting a student, whether that's physically restricting them from a class, restricting them from an activity, if you don't have tangible evidence to do so, you are liable for that. So all the ones we just talked about, they would be considered intentional torts. Now we're going to talk about unintentional torts. Unintentional torts, an unintentional tort is a wrong wrong perpetrated by someone who fails to exercise that degree of care in doing what is otherwise permissible. That is acting negligently. So it's not necessarily something that somebody tried to do, but because they weren't paying attention or they didn't follow a process correctly, something bad happened. Negligence is perhaps the most prevalent source of litigation involving injury to students. So again, if a teacher's like on their phone during recess and not paying attention to a kid, and a kid runs out in the middle of the street to grab a ball, and heaven forbid gets hit by a car, you didn't necessarily do anything, but by not doing something, you are held liable for that. Negligence is generally viewed as the failure to exercise a reasonable standard of care which results in harm or injury to another person. Most negligence cases involve civil wrongs, although there may be some instances in which the accused face both civil and criminal charges. So unintentional torts kind of bring us into the standard of care. Standard of care is an important concept in cases involving liability of school personnel. It requires that school personnel exercise the same degree of care which a person of ordinary prudence would exercise under the same or similar conditions. So as a teacher, not only are you supposed to go above and beyond these, but you have to at least meet that benchmark of what the average person would be doing in a situation. This standard of care will vary depending on particular circumstances. So again, they do have to take into account safety for yourself in situations. The level of care due to students changes based upon the age, maturity, experience, and mental capacity of the student, as well as the nature of the learning activities in which they are involved. So a 5-year-old kindergartner is going to have a different standard of care than a 18-year-old senior.
Sorry. Okay. The defense. Sorry here. Okay, defense is for negligence. I can't even say that. If the evidence reveals that persons claiming injury exhibited conduct that fell below reasonable standard, liability charges against school personnel, then maybe it may happen. The assumption of risk is commonly used as a defense in situations involving various types of contact-related activities as athletic teams, pep squads, and even intramural activities that take place. Even though a student assumes an element of risk, it does not relieve school personnel in cases where they fail to meet a reasonable standard of care based upon age, maturity, risk, and nature of the risk associated with the activity. So under comparative negligence, acts of those responsible are compared to the degree attributed in an injury situation. So juries will normally determine the degree, and which may range from slightly to ordinary to gross, depending on the circumstances.
Now we get into the aspect of immunity. Immunity as a legal concept is diminished in terms of impact. It is based on the old common law of sovereign immunity. The king can do no wrong, meaning that the state or federal government is protected from suit and cannot be held liable for injuries that result in the proper execution of governmental functions. So immunity means that you can't be charged or you're not going to be punished in any sort of way. Strict liability. Strict liability occurs when individuals are held liable um, who are not directly at fault. Strict liability typically emerges when students are involved with ultra hazardous activities. The view surrounding strict liability is that someone must compensate the injured party for injuries. The party best able to bear the burden is most typically assessed with damages, and strict liability is oftentimes referenced as liability without fault. So, say that there's one group, the school, and a student gets injured um, in PE class, like severely. They break their leg. Um, and they're doing something that's school related, not just messing around. The school is going to be held liable since they're more able to bear that burden of the cost to pay for the student's surgery, anything that may have occurred after the injury, so on and so forth. A determination as to whether an activity is ultra hazardous centers around whether the risk is so unusual based on the seriousness of it or the circumstances surrounding it. So, say that the student breaks both their legs now. I would consider that ultra hazardous because that's most likely less likely to happen than any other injury that a kid could obtain at school. Um, Strict liability in cases involving public schools rarely occurs, but the prospect that they may occur does exist. So, like I said, a kid could possibly break both their legs at school in PE class, but who knows? It's always just the thought in the back of admin's head or school's mind, thinking, "Oh, wow, this could happen. We got to be able to cover ourselves in case this does happen."
Now we're kind of getting into what happens in terms of liability that's not directly on the school grounds. So liability, one example of that's going to be liability involving students at bus stops. So parents rather than officials are liable for the behavior of their children at bus stops when students are waiting to board the bus. When the child boards the bus, liability may arise depending on the facts surrounding an injury to this student. School or district policy should serve as a source for governing student behavior on school-sponsored transportation. So districts, each district may have a different way of handling liability when it comes to uh, gray areas such as this. And that's usually why you see bus drivers who are so strict in terms of their expectations because it is a very gray area. And especially depending on your district, if your district's very strict, anything that happens with, anything involving our school name at all, we're liable for, you're going to see some extra precautions taken. Parents and students should be briefed on these policies, including consequences when rules or policies are violated. So usually at the beginning of the year, all the students, they get to go out to the buses and meet the bus drivers, and they explain, the expectations for how they should be acting, usually how they should cross the street as well. This is a large part of that. Continuing on with that, when school officials are aware of the student's conduct at the bus stop may result in injury, they should respond by informing parents and students of dangerous acts that may result in penalties to those students who commit dangerous acts. If the student is willingly doing something dangerous that they should not be doing, since it's a gray area, it's in the school's best interest to take precautionary steps and document this. So if something serious was to occur and the student was to get hurt, they've clearly documented that they've been aware of this. They've tried to warn the child, this is dangerous, you could get hurt. They've done everything they can. School officials must ensure that bus stops are not located in heavily trafficked areas or hazardous areas that may prove harmful to students. It's very common to see them at corners where there is a four-way stop or at minimum a two-way stop. And that would be a great example of that. School bus operators must be proactive in supervising students to ensure that student misconduct does not contribute to harmful conditions for students. Again, bus drivers, they're going to be strict. It's a gray area. It's for the student's safety. Lastly, any serious acts of misconduct should be promptly reported to school officials. So again, going back to that, not only should you be documenting when situations look like they could become potentially dangerous, but if something does happen, right away to school officials, parents, in severe cases, local law enforcement, get everything done as fast as you can.
Extracurricular activities and liability. With all the events that go on at night, the extracurricular activities, it's important also to encourage students to do these activities. That creates a healthy lifestyle and builds strong social relationships. But they also have to have leaders there, and the activities will also facilitate leadership, skill development, and build a greater sense of community and school pride. Most of the activities involve a physical movement and contact that requires a greater degree, so supervision is definitely a must at all of these activities. School personnel have a duty to warn students of any danger that goes along with that activity and instruct them on proper techniques to ensure that they're adhering to proper instruction. So just making sure that the kids are playing by the rules, they're not getting out of hand, or it doesn't get too competitive, just making sure everybody's doing it correctly. Participation guidelines should be developed and shared with parents and students that govern the student participation in these extracurricular activities. And a concerted effort should be made to ensure that students understand the expectations and that they're made aware of what their behavior should look like and sportsmanship should look like before beginning these activities. Failure to exercise a degree of care for the safety of students may result in the liability charges against a school personnel or the district, depending on the facts surrounding the injured students. What was the actual, how were the students injured? What happened? What was the whole situation? Kind of digging in and figuring out what the cause of it all was to then see what the charges may be.